This is Constitutional Law Part 1, looking at powers of the federal government. Judicial power, Article 3, Section 1. When you're talking about judicial power, it's always Article 3. Article 1 is Congress. Article 2 is the executive. Article 3 is the judiciary. Article 3, Section 1. Courts are independent of the President, Congress, political process. They have subject matter jurisdiction. This is federal question or diversity, which we just discussed in civil procedures. They have the authority to review an act of another branch. That's found in Marbury. They have the authority to review decisions of the state's highest court. That's from Martin. Or state statutes, court decisions, executive orders. That's from Fletcher. They have the authority to review these for constitutionality only, not whether they're correct or not. Only for constitutionality. Judicial power, limitations on judicial power is found in the 11th Amendment. A state cannot be sued by a citizen of another state. That's the 11th Amendment. And a state cannot be sued by a citizen of itself, of its own state. That's the 11th Amendment as interpreted by Hands. Now, the 11th Amendment only bars suits for damages. A suit is okay if the damages are sought against a state officer in an individual capacity. And it bars suits for damages, but suits for damages are okay in the context of that suit being against a state officer in its individual capacity. You can sue local governments, and the state and or federal government can sue a state. So states can sue each other, the federal government can sue pretty much everybody they want. Judicial power, the Supreme Court in original jurisdiction. The Supreme Court has original jurisdiction, meaning it's the first court to hear certain cases. And these cases are cases involving ambassadors, ministers, councils, or where a state is a party. Looking at judicial power of the Supreme Court and appellate jurisdiction, so how do cases get appealed to the Supreme Court? There's two ways that they can get there. They may hear. There are cases that they may hear, and there's cases that they must hear. Cases that they may hear come to the Supreme Court on certiorari. This is discretionary review. So cases going through the appellate courts, the justices review these cases, and 4 justices of the court must vote to accept that case. If they don't, court stays in lower court decision holds. There are also cases that they must hear. So may hear is discretionary review, also called certiorari. There are cases that they must hear. These are direct appeals of decisions of injunctive relief from a 3-judge district court panel. The Supreme Court must hear those cases. Judicial review in operation, looking at standing, you must have standing. To have standing, you must establish an injury in fact, which means it must be concrete and particularized. The harm need not be physical or economic, but may be an effect to recreational activities. And it may be a future harm, but it must be actual and or imminent. So you have to have an injury in fact. You also have causation, which means it must be traceable to the defendant's conduct. Injury in fact, causation, and redressability, meaning that the decision will remedy the harm suffered. Looking at judicial review and timeliness, this is the mootness, ripeness concept. Ripeness is where the plaintiff has suffered, has experienced a real injury. Mootness is where further legal proceedings would have no effect. Looking at judicial review and additional issues, specifically advisory opinions, the court may not render advisory opinions. They may only render opinions on actual cases and or controversies. They can't just run around all willy-nilly saying, oh, you should do that. They can't do that. It has to have a case or controversy in front of the court. Declaratory judgments are okay. Addressing political questions such as where the Constitution assigns the decision-making on a subject to another branch or decision making on that subject is not inherent to the judiciary, those aren't okay either. Political questions, bad. Declaratory judgments, okay. Advisory opinions, bad. Looking at the powers of Congress, the Commerce Clause, and this is again going to be in Article 1. Article 1, Congress. Article 2, Executive. Article 3, Judiciary. Article 1, Section 8, Clause 3, very broad clause, includes essentially all activity involving and or affecting two or more states. It gives Congress the power to regulate channels of interstate commerce. These are things such as highways, and instrumentalities of interstate commerce. These are things such as trucks. And activity that substantially affects interstate commerce. However, the regulation must not infringe on another constitutional right. Now, again, the Commerce Clause is a very broad clause. It allows Congress to regulate things that may not be economic activity. And this includes regulation of non-economic activity, such as the requirement to buy health care, which is ridiculous, possession of firearms, which is understandable. Powers of Congress to tax and spend. Again, power of Congress, it's Article 1. Tax and spends, Article 1, Section 8. Taxing and spending is the exclusive power of Congress. Taxing must have a reasonable relationship to revenue production, or Congress must have the power to regulate the activity being taxed. Congress must spend for the general welfare or public purpose, not to pursue other enumerated powers. Looking at the power of Congress over aliens and citizenship, aliens have no rights to enter. Entry may be refused even for political beliefs. That's from Mandel. Aliens already in the United States, however, this power over aliens is restrained by the Due Process Clause, or due process of the Fifth Amendment, and that's from Davis. However, aliens may be removed after notice and removal hearing. That's 8 U.S.C. 1229. Looking at the powers of Congress and the Necessary and Proper Clause. Congress has the power to do things that are necessary and proper to enact any legislation. So they can act in legislation necessary and proper to execute any authority granted to any branch of the federal government. That's from McCulloch. Now, the Necessary and Proper Clause and the authority to enact legislation necessary and proper to execute authority granted by a branch of the federal government or granted by the Constitution to any branch of the federal government. This is not an independent power. It only allows other powers to be exercised. On the exam, the Necessary and Proper Clause is never the correct answer if it is by itself. It must be with an enumerated power. And that completes part 1 of Con Law.